Question is, what outgoings should be documented in the lease agreement? To ensure comprehensive and transparent allocation of property-related expenses between the landlord and tenants, thoroughly document the various outgoings with the help of an experienced commercial real estate agent, coach, within the lease agreement. By explicitly outlining these expenses and the corresponding percentage of total property outgoings payable by individual tenants, both parties can operate in the framework that fosters accountability and understanding. An experienced commercial real estate lawyer should fully document the expenses in the commercial property lease agreement. This set out the range of categories, each necessitating a more profound exploration to illustrate the significance and potential impact. Break it down. For example, building insurance. Building insurance is crucial to any lease agreement, safeguarding the property against unforeseeable events such as fire, natural disasters, or vandalism. The lease agreement ensures that financial responsibilities distributed equitably by specifying the tenant's share of the insurance costs. For instance, if the annual building insurance premium amounts to, say, $10,000 and the tenant's allocation is 30% of the net lettable area, the tenant could contribute $3,000 towards the insurance coverage. Body corporate fees or levies. The lease should outline the tenant's portion of the lease levied by the property body corporate. These fees contribute to community facilities, maintenance, and improvements. The lease agreement fosters transparency by detailing the exact portion the tenant is liable for. For instance, if the body corporate fees total $5,000 per annum and the tenant's responsibility is 40%, the tenant's annual responsibility will be $2,000 in that situation. Property management fees. They are fees associated with a property's management. That includes services such as tenant liaison, maintenance coordination, and administration costs. The lease agreement avoids ambiguity by clarifying the tenant's share of fees. For example, if the property management costs, let's say, $2,500 a year, the tenant's contribution is 20%, then the tenant's yearly payment would be $500. Repairs and maintenance. The lease should specify the tenant's obligation towards general wear and tear, repairs, and property maintenance. This includes routine upkeeping and service contracts, such as air conditioning units, elevators, landscaping, and roofing repairs. The commercial property lease agreement details these responsibilities and ensures property is properly cared for. For instance, if annual maintenance and repairs amount to, say, $8,000 and the tenant's assigned portion is 25%, the tenant's contribution would be $2,000. Land tax. The allocation of land tax expenses should be outlined in the lease agreement as well. While some leases place the responsibility of land tax to the landlord, others may stipulate a partial contribution from the tenant. Clearly outlining this avoids misunderstandings. So if the annual land tax is $4,000 and the tenant's share is, say, 10%, the tenant's yearly obligation will be $400. Council and water rates. Documenting the tenant's portion of water and council rates is crucial for accurate expense contribution and distribution. These rates contribute to local services and utilities. By allocating the tenant's allocated percentage, the lease agreement establishes accountability. For example, if the annual rates total $3,600 and the tenant's contribution was 30%, then the tenant's yearly payment contribution would be $1,080. Special garbage collection. This normally, the smaller places, they may not charge extra for rubbish, but you got heavy industrial places or restaurants or people that contribute a lot of wastage. They usually organise their own rubbish or some arrangement with the landlord. Any specialised garbage collection fees should be expressly detailed within a lease agreement. These charges relate to specific waste disposal services that benefit the property. By clarifying the tenant's responsibility, the lease agreement prevents disputes if garbage collection costs $500 annually and the tenant shares 50%. Contribution assessed $250. So you've got situations where, there may be inequality because one tenant has more garbage than the other. So there has to be something negotiated, which is not unfair to each party. In conclusion, the lease agreement is pivotal for transparently allocating property-related expenses among tenants. The lease agreement clarifies financial obligations by comprehensively documenting each category of outgoings and specifying the percentage borne by individual tenants. This approach ensures a harmonious landlord-tenant relationship and minimal potential disputes over expense distribution. Retail leases are relatively similar to commercial leases and can be subject to alternative methods and conditions as set out and described in the Retail Leases Act. This varies from state to state, country to country. Types of outgoings. Outgoings for commercial property is paid to the landlord in various ways as outlined in the contract of lease. The most common methods are the following. A net lease. With a net lease, the tenant is usually charged separately to the rent. The term could be monthly, quarterly, 6 monthly, or annually, depending on what was negotiated at the commencement of the lease. This outgoings expense is usually calculated from the actual number of outgoings paid the previous year. From this, a budget is given to the tenant for his or her year's schedule. Throughout the year, adjustments as per the lease can be made for any variances from the actual and budgetary figures. So there'd be extra charges or reduction in charges to balance it out. You may have a gross lease. With a gross lease, there is one payment, which includes the rent and outgoings. There's direct deduction method. Under this method, the tenant is charged as per the invoices paid by the landlord. This is usually done at the same time as the invoice. What are recoverables, outgoings in commercial leases? Under the Leases Act, the landlord is only entitled to recover reasonable expenses paid by the landlord in promoting a retail property in a shopping centre. And this varies again between state to state, country. Charges, taxes, rates and levies paid by the lessor or landlord. Reasonable expenses in direct relation to the maintenance and repair of the property. Commercial property lease states a tenant is to be liable for the outgoings, must provide provisions requiring the lessor to account to the less at the end of the period of the actual expenditure compared with the estimate and make adjustments for any variations. They must also give budgetary figures for the future outgoings and particular intervals, as stated in the lease. How are the outgoings paid for commercial property? There are several ways in which the tenant pays outgoings to the landlord. They include usually tenant is given an estimate at the start of the year, depending on the commencement, and it could be 6 monthly, 12 monthly, or whatever. At the end of the year, an adjustment is made depending on the amount paid, either higher or lower than the estimate. The other primary method is to charge every 3 to 6 months on amounts received during that period and to send an invoice when the landlord gets the bill. This is the fairest way because everything is always up to date, but it can be more work in invoicing all the time. The method by which outgoings are paid could affect the property's value and add to the landlord's administration costs and investment return. For example, continually chasing up tenant for outgoings would cause problems with the landlord's costs and cash flow. Additionally, administration and possible legal expenses involved in chasing up invoices did not pay in a reasonable period, as outlined in the lease. I always encourage my clients to get new tenants to pay quarterly in advance for cash flow purposes. How you do it depends, which is what I do. Discuss it with your commercial real estate agent, commercial real estate coach. What should one do before entering a lease? For anyone considering a commercial property lease, there are a few crucial steps to take before diving in. These steps help the landlord and the tenant understand their responsibilities and ensure a smooth lease agreement. Here's what you should know and understand before signing a lease, and what to keep in mind. When you're a landlord or lessor renting out a space, or a tenant looking to lease a space, there are essential things to remember. These steps ensure that both parties are on the same page and are fully aware of the obligations for the lessor or the landlord. Before the lease is signed, the lessor is responsible for being open about the cost they need to pay. All these costs, called outgoings, must be mentioned in the disclosure statement document. This document is shared with the tenant before they sign the lease. It's like giving them a clear picture of what they'll have to pay in addition to the rent. For the lessor tenant, as the lessee or tenant, you must carefully read and understand everything in that lease and the disclosure statement. These documents list all the details of the lease, including what you're responsible for. The lease mentioned the lettable area, which is the space you're renting, etc. This is important because some costs are based on the size of the area you're using. The key to successful lease: seek professional advice to make sure you're making the right decisions and fully understand your lease. It's wise to get some professional help. A lawyer, solicitor specializing in commercial property can be your guide. I'll carefully read through the lease and disclosure statement and explain every little detail to you. This way, you'll know exactly what you're agreeing to before you put pen to paper. Why it matters. Imagine signing a lease without knowing if all the costs involved. It may lead to unexpected bills and confusion later on. Or, as a landlord, you may not adequately disclose all the costs, causing legal disputes with a tenant down the line. By following these steps with your commercial real estate, commercial property coach, and seeking the right commercial advice for your commercial real estate lawyer, you can avoid these pitfalls and ensure a fair and transparent leasing. Whether you're a landlord or a tenant, it's crucial to be thorough and well-informed before entering leasing. Transparency and understanding on both sides contribute to a successful leasing experience and positive relationship between all parties involved. Over the last 30 years plus, I've seen many disputes between tenants and landlords because things weren't set out properly in the first place. Get the right advice. Right real estate specialist, working along with your commercial real estate specialist lawyer, ensures that these things don't happen in the future. If I can help you in these situations, feel free to contact me. My details are below.